Surveillance regimes in contemporary India. Kumar Singh. Introduction. The tools of measurement survey census have long marked and thereby made legible that lies within the purview of a state, consolidating and augmenting its power of revenue collection, garnering military service, enforcement, and policing. Whether post, post as surveillance state indicating the presence specify of the security state or as an interlocking system of the surveillance regimes. Surveillance presents itself as a set of techniques embedded in specific practice of rules for harnessing, containing, and monitoring the state's territory and its population. Over the years, these tools have become more sophisticated and specialized, enabling the state to reach into society in unprecedented way, creating new and differentiated relationship of power. The accumulation of surveillance regimes in the wake of the ongoing war on terror, emphasis in original, has raised significant concern around the rights to life and privacy and the freedoms of association and expression. Indeed, electronic surveillance through wiretapping and biometric marking of individuals have permeated and transformed the everyday lives of people, while the closed circuit television cameras, CCTVs in gated communities manifest how security has been privatized. Data vigilance by the state through the legal instrument policing electronic communication reflects how the states regulates what people watch and how they express themselves. Most significantly, mode of regulatory controls have spilled into the electoral domain, with electronic monitoring of elections by the Election Commission of India through videography of election campaigns having become a part of the established practice of the fair and free elections. The Commission's models of code of conduct, for example, empowers it is to sanitize the election campaign by keeping a watch on political parties, conducting stop and search operation, curtailing wall writing through the invocation of laws prohibiting defacement of walls. This chapter, however, will confine itself to an examination of surveillance regimes in India and the aftermath of the global war on terror to show how state practices of surveillance accumulate incrementally. It argues that new techniques of surveillance in the form of the electronic traces on citizens, facilitated by anti-terrorism legal regime, have transformed the reach of the state, indeed the spectrum of the dominance that characterized earlier forms of surveillance is rendered nebulous and intangible, but increasingly more penetrating through technologies that do not require proximity between the law enforcers and the people. At the techniques of surveillance developed in the ordinary form of the policing as they exist in the police manuals based on the stop and search operation and the assumption of suspicion surrounding specific communities have lingered on. The old modes of surveillance in the form of the local community policing have persisted and in some cases have been revived in a way that produces extraordinary power effects for the state. Part 4 to 4.2 of this chapter examines the surveillance systems that have been generated by law designed to address terrorism. The war on terror has brought specifically designed legal provisions into the state books, while anti-terror laws exist earlier at the national level. For example, the Terrorist and the Disruptive Activities Prevention Act. Terrorist and Disruptive Activities Prevention Act 1985, which was enacted to counter the separatist movement by militant Sikh groups in the state of the Punjab. The Prevention of Terrorist Act 2001 POTA was distinct in allowing interception of the telephone conversation and giving the records of these interception in evidentiary value in the trial under the Act. The Unlawful Activities Prevention Act 1967 UPA, which was amended in 2004 to accommodate provisions of repealed POTA, permitted the persistence of electronic interceptions, allowing the state to tap and eavesdrop on telephone conversations, scrutinize financial transactions, and ban suspicious activities. Electronic surveillance as an innovation of POTA and its persistence in the UAPA was presented by the government as the necessary measures for addressing the new context of the war of terror. Emphasis on in original characterized characteristics by the ubiquitous at undetectable aspect of terrorism. These contexts generated a notion of danger that could no longer be contained by ordinary policing. The danger posed by the spectral terrorism, as Julia Eckert explained it, refers to a general situation of threat arising from the de-individualized and the diffuse Islamic terror, which works on the assumptions that the enemy could be everywhere and anywhere nearly. Such an assumption lays down the ground for an universal campaign of investigation, interrogation, confiscation, detention, surveillance, torture, and punishment on, for the first time, a genuinely global scale, not only where the terrorism does manifest itself, but where it might manifest itself, which could, of course, be anywhere. Thus, new terrorism is attributed with an unprecedented, unprecedented and extraordinary potential for destruction emerging from its allegedly novel form of organization and transnational, loosely connected cells. It is also seen as creating conditions for new and more effective security measures. These measures could no longer be confined to police investigation for prevention of an identifiable event, but were raised to a new ground for action pertaining to what people might at some point to changing security from a matter of politics into technology. POTA and the UAPA sought to secure for the Indian state the technological competence to counter what were presented as conditions of an extreme necessity generated by global terrorism. While POTA and UAPA concern themselves with the extraordinary situations of terrorism, the Indian Telegraph Act 1885, which has been on the statute books since the colonial period, provides the modalities of surveillance of citizens in normal times. More recently, the Information Technology Act 2000, IT Act as amended in 2008, laid down the templates for extraordinary modes of electronic spying and surveillance of all flow of digital communication to regulate what it calls transaction carried out by means of the electronic data interchange and other means of the electronic communication. This development is explored in the section 4.3. Section 4.4 of this chapter will examine surveillance regimes in the Indian border zones as distinct from the depressed and the ubiquitous spectral terrorism. These border zones refer to specific states in India in which the conditions akin to armed conflict exist. In a state like Chhattisgarh, for example, the extremism of armed left-wing radical groups and the state's armed operation against them have resulted in an extraordinary reinforcement of the security apparatus of the state. Security laws like the Chhattisgarh Special Public Security Act 2005 Chhattisgarh have been used widely by the Chhattisgarh government along with the UAPA and the provision of Indian Penal Code 1860 pertaining the sedition 124A and waging war against the state 120A. Yet it is through two innovations into surveillance techniques that the Chhattisgarh government has sought to buttress and make its security apparatus more effective. First, it has sought to use modern gadgets such as a global positional system (GPS) and unmanned aerial vehicle (UAVs) to pierce the densely forested parts of Chhattisgarh inhabited by the tribal people. These parts were considered unpenetrable and inaccessible not only because of the forest cover but also due to the entrenchment of the armed groups among the tribal populations. And thus, simultaneously, the Chhattisgarh government has resurrected and the colonial practice of the community policing. It has invoked provisions of the Indian Police Act 1861 (IP) to set up a force of special police officers (SPOs) drawn from along the tribal people. The invocation of the IPA has resulted in the tribal population becoming conflict in the participating in its own policing, leading to the creation of new fault lines within the tribal community and an accumulation of social conflicts around the forms of the domination that emerged from the militarization of the community by the state. Of this chapter takes the discussion further by examining the ways in which the biometric mapping of the population and the allocation of unique identification number has opened up possibilities of increased powers of the surveillance and sorting by the state. The fault lines in the debate of on the UID in the India has developed broadly along two axes. On one hand, apologists point to the utility of the UID as a tool of efficient and good governance and ensuring transparency, corruption, and uh, leakage-free delivery of service to all and welfare of the disadvantaged. On the other hand, there are those who see UID as an essential manifestation of security state as an inextricable part of the range of the counter-terrorism measures that have proliferated in the recent past to equip the state for mounting and the maintaining effective surveillance. The surveillance regime of anti-terror laws, TADA, which was passed in 1985 and lapsed in 1995, was enacted in response to the movement of the separate Sikh state of Khalistan. The United Nations Security Council Resolution 3073 adopted on 28 September 2001, mandating a concerted international efforts against global terror networks have become the most frequently cited reason for another anti-terror law in India. The attack on the Parliament building in New Delhi on the 13th December 2001 the part precipitated the enactment of the POTA. POTA introduced an innovation in the counterterrorism measures in India, emanating from the professed need to address the new technique of terror and its global networks, making an exception to the law of evidence in India. It allowed for electronic interceptions to be submitted as primary evidence, and a special POTA courts designated to hear cases brought to trial under the Act. The repeal of POTA in 2004 was followed closely by an amendment to UAPA. Unlike POTA and TADA, UAPA was intended to be a permanent law. The amended UAPA included a number of provisions from POTA, most prominently those pertaining to the interception of the telephone and electronic communications, without, however, the safeguards that were present in POTA. POTA provisions pertaining to interception of the communication in the certain cases defined what constituted interceptions, laid down specific procedures for the appointment of a competent authority to whom applications to authorize interceptions could be made, provided for institution of a specific safeguard, including a review process to confirm whether the procedures had been allowed, and require the preparation of an annual report of the interception. A police officer of the rank of the superintendent of the police who was supervising the investigation of any terrorist act under POTA could submit an application in writing to competent authority for an order authorizing interceptions. The application was to be accompanied with the details of the facts and circumstances relied on by the applicant that made interceptions necessary, the type of the communication to be intercepted, and the identity of the person whose communication were to be intercepted. The order by the competent authority was similarly to specify the identity of the person whose communication was to be intercepted and the nature and location of the communication facilities and the agency authorized to intercept and the duration for which interception was authorized. A copy of order of the competent authority was to be submitted to review committee with all relevant paper. The evidence collected through the interception of the wire electronic or oral communication was admissible as evidence against the accused in the POTA court. with the condition that a copy of the order allowing interception was to be given to the accused 10 days before the trial. It was the task of the review committee to review every order passed by the competent authority. Public disclosure of the contents of the interception was prohibited, but an annual report giving full details of the interceptions had to be prepared by the central and state government and placed before the respective parliaments. In 2004, following the repeal of quota, the central government made amendment to UPA to insert provisions allowing for electronic interception. The amended UAPA was exceptions to the provisions of Indian Evidence Act 1872 Evidence Act to make evidence collected through uh, interception of wire, electronic or oral communication under existing laws, including ITA and IT Act, admissible as evidence against an accused being tried under UPA like POTA, UPA to request that a copy of order be made available to accused before the commencement of the trial, but there is no provision for institution of a review committee or the submission of an annual report by the central state governments. The evidentiary worth given to the electronic interceptions under POTA was tested in State versus Muhammad Afzal, the parliamentary attack case in which the first judgment by the POTA court was delivered. The case against the four accused was built largely around evidence garnered through the interceptions of telephone communications as well as confessional statement made by three of accused. As mentioned, As mentioned earlier, while ITA authorizes interceptions, intercepted material may be presented as primary evidence proving guilt only under POTA. For an interception to be accepted as valid evidence by the POTA court, the investigation agencies should have followed the procedural requirement laid down in the POTA itself. These requirements, the defense counsel and the parliamentary attack case pointed out, were not adhered to by investigating agencies and sentencing judgment. The POTA court recognized that the procedural lapse under POTA had been committed by the investigating authorities in intercepting telephone calls. It did not, however, question the veracity and credibility of the evidence from the interception presented by the prosecution, arguing that procedures should ultimately serve the cause of justice. The POTA court steered clear of the procedural requirement under POTA and instead accorded the interceptions procedural legality under the ITA. The POTA judge opened that the provisions of Telegraph Act of Interception are pari materia with the provisions of POTA as a rule of the statutory interception. The invocation of the pari materia means that POTA and the ITA could be construed as law concerned with the same matter, that is, the public emergency and safety, and the provisions of one could be interpreted with the reference to the other of the purpose of facilitating uniformity in law. The condition under which the interceptions were ordered on the day of the attack, namely to apprehend others who may have been complicit in the attack or were planning other attacks, met the requirements and norms of the public emergency and the public safety laid down by the Supreme Court in People's Union of Civil Liberties versus Union of India (PUCL) for interceptions under the ITA. This case will be discussed in more detail in the next section of this chapter. This mode of interception led to POTA judge to conclude that the interception under POTA without the procedural safeguards prescribed by it could not be construed as arbitrary and illegal because the conditions in which it was invoked satisfy the requirement of extreme necessity of interceptions under the ITA. The interceptions were therefore able to be admitted as evidence against the accused under POTA. Over the past decades, as the next section of this chapter will show, the enactment of the IT Act in 2000 and its subsequent amendment in 2008 has allowed the government to bypass the safeguard laid down by Supreme Court and PUCL, while random sweeps of phone calls and the emails and wiretapping by intelligence agencies have become rampant. Diamond's parliamentary oversight and judicial review have simultaneously beacon constitutional protection for the right to privacy and the freedoms of speech and association. E-surveillance form from the ITA to IT Act. Unlike the United Kingdom, where the legal prescription for interception came as late as 1985, in India, statutory history of the interception started a century before in 1885. Significantly, the Interception of Communication Act 1985 UK intended to circumscribe ministerial authority by law. In India, the limits to executive powers were introduced by judicial intervention. In November 2010, the Aradia tapes exposes in a news magazine brought before the public significant aspect of the relationship between the politics and the interception. The tapes in question were of telephone conversation between the Neera Radia, a political lobbyist who ran a public relations firms, and a number of senior journalists, politicians, and corporate house bosses. The conversation revealed behind the scenes lobbying and decision making process, ranging from the appointment of the ministers to the award of government license and contract. The tapes also opened up a pano Pandora's box of large scale electronic eavesdropping by state and non-state actors that was being carried out routinely in the country, beyond the terrorism related surveillance carried out under the UAPA and earlier under POTA. Subsequently, the Central Bureau of Investigation, which was investigating the 2G spectrum allocation case and had asked the Directorate General of Income Tax Investigation to tap phone conversation, admitted in an affidavit to the Supreme Court to having almost 6,000 intercepted recording of radio. The Supreme Court ordered the government to furnish the court with documents to show that the required procedures regarding electronic interception had been adhered to. The court was asking in particular for documents to show that a competent authority had authorized the interception and subsequently entrusted them to appropriate safekeeping. The Supreme Court's insistence on the presentation of the evidence of this evidence emanated from the procedural requirements that were inserted into ITA. Following the Supreme Court judgment in the PUCL, the petition leading to this judgment was a public interest in litigation writ filed by the People's Union for Civil Liberties in 1991, and the wake of report of the tapping of the politicians' phones by the CBI. The petition before the Supreme Court sought to bring to its attention the absence of the procedural safeguards in the ITA Section 5(1)(2) of ITA gave the central government the power to intercept messages on the occurrence of any public emergency or in interest of the public safety when necessary and expedient to do so in the interest of the sovereignty and integrity of India, the security of state friendly relations with the foreign states or public order, or for preventing incitement to the commission of an offense. Section 7(2) of the ITA empowered the government to make rules to prevent improper interception and disclosure and the preservation or destruction of the interception related documents. In this petition to the Supreme Court, PUCL challenged the constitutional validity of 5(2) of the ITA and asked that the provisions be suitably read down to include procedural safeguard to prevent arbitrary and indiscriminated phone tapping, arguing that the right to privacy is a fundamental right that may be read into arts and 1921 of the Indian Constitution. Rajinder Sachar, representing this PUCL, argued for the prior judicial sanction as the only safeguard that could eliminate the unreasonableness of the provision. from Kapil Sibal, who was assisting the Supreme Court. The question of procedural safeguard was equally significant, but he preferred writing safeguard and 252 of the Act itself rather than submitting it to the prior judicial scrutiny. The Supreme Court agreed that taping phones was a serious violation of the privacy, which amounted to the technological eavesdropping. It rejected prior judicial sanction on the grounds that any such sanctions would be futile in the absence of the effective procedural safeguards in the law itself. The Supreme Court recommended, therefore, the telephones may not be tapped except under the conditions laid down in the section. That is where there is a public emergency and threat to public safety, and only under orders made in the writing by an authorized minister or officer that disclose the region for taping. A review committee set up within 2 months of order would investigate the order's relevance, setting it aside in the case of contraventions and ordering the destruction of all intercepted material. If appropriate, the committee would record the findings. The Supreme Court instructed the government to establish rules to make the order effective. Rule 419A of Indian Telegraph Rules of 1951 was in 1999. While delivering the constitutionality of 52 of the ITA, the Supreme Court averred that the right to privacy, although not identified in the Indian Constitution as a fundamental right, had come to be construed as the implicit in the right to life and liberty guaranteed by the Article 21, referring to the judgment in the Khadak Singh versus Uttar Pradesh. Khadak Singh. The Supreme Court concluded that the meaning of the word life and the expression personal liberty as they figure in Article 21 need to be understood in the relation to the constitutional objective of the dignity of the individual as laid down in the preamble. The meaning of the personal liberty in Khadak Singh was expanded to mean not just the freedom of movement but also a citizen's freedom from encroachment on his or her private life. Having read the right to privacy into the fundamental right to life, it followed that the right could not be curtailed except according to the procedure established by law. The Supreme Court further opened that the right to privacy would include telephone conversation in the privacy of one's home or office. Telephone tapping would thus be in the violation of Article 21 of the Indian Constitution unless permitted under the procedure established by the law. The court also concluded that the right was similarly implicit in Article 91b of the Constitution, which guarantees a right to express one's convictions and opinions and could be curtailed only if it came with the grounds of the restriction set out in Article 92. The protection against arbitrary interception started pattering out with the enactment of the IT Act, and the IT Act extended the reach of interception from the telephone to computer. It also removed the two conditions that had to be satisfied under ITA in order to justify an infringement of the right to privacy, public emergency, and public safety. The IT Act worked on the principle of the permanent state of emergency and did not require the extraordinary condition of public emergency should actually exist in order to justify the interception of the information transmitted through computers. The UAPA and earlier POTA had created exceptions to the Evidence Act so that the interception could be admitted as evidence. The IT Act amended the Evidence Act itself to enlarge the meaning of evidence to include transactions carried out through electronic data interchange and other means of the electronic communication. All electronic exchange was henceforth considered the electronic record admissible in a court of law as documentary evidence. Chapter 11 of the IT Act lists a range of offences including among others cyber terrorism, which carries a punishment that could extend to the imprisonment of for life. Section 69 gave the government to the power to intercept any information transmitted through any computer resource. In the interest of the sovereignty and security of India, its relations with the foreign countries, public orders are for preventing incitement to the commission of the any cognizable offense under the IPC. In 2009, the following the 26 November 2008 terrorist attacks in Mumbai, this section was amended to empower the government to intercept, monitor, or decrypt or cause to be intercepted or monitor or decrypt any information generated, transmitted, received, or stored in any computer resource. The amendment overrode all other acts in the event of the conflict and brought within the purview of IT Act not just computers but also mobile phones, SMS, emails, email messages, and internet search engines effectively. Therefore, 2009 amendments expanded the surveillance capacity of the state and broadened the scope of activities. Identified as criminal offences under the IT Act, empowering the government to collect and dignity digitally transmitted data without warrant and exercise control over any matter posted on the internet. The IT Act provided for up to 7 years imprisonment for the internet service providers and the telecom operators, search engines, and owners of cyber cafes for not releasing, blocking, or eliminating data if the government instructed them to do so. The IT procedure and safeguard for blocking for access of information by public rules 2009 set out guidelines whereby the central government could issue directions for blocking access by public to any information generated, transmitted, received, stored, or hosted in any computer resource. Rule 3.2 of the IT Intermediary Guidelines Rules 2011 obliged companies to have rules and conditions of uses that ensured users did not host, display, upload, modify, publish, transmit, update, or share any information in contravention of 79 of the IT Act. This included defamatory of sins and the pornographic content as well as grossly harmful, blasphemous, harassing, and hateful speech. The provisions of the IT Act thus enable the state to monopolize the legitimate use of cyberspace, regulating it in a way that eroded the privacy of citizens. It simultaneously redefined the public space, squeezing spaces of the free expression into the realm of the private and the outside the epistemic community of the digital network of the cyber commons. The manner in which the 66A of the IT Act, which makes it an offense to send the offensive messages through a communication service, has been used in the recent time to punish persons for posting on social network sites such as Facebook, Orkut, and is illustrative for this. Thus, alongside demands for responsible and the rule-bound interceptions, there have has emerged a monitoring tendency toward the securing cyberspace for surveillance by the state. Shiv Shankar Menon, India's national security advisor, stressed the need for the whole of government cyber security architecture. Writing in the Hindu newspaper in the May 2012, Menon stated that the government was in the process of putting in the place the capabilities and system that will enable it to deal with an anarchic view new world of the constant and undeclared cyber threat attack, counter attack, and defense. Significantly, the National Technical Research Organization (NTRO), one of the institutions Menon mentioned as crucially asked to deal with the protection of India's critical security cyber infrastructure, has been actively conducting electronic surveillance. This is despite that fact that is not an agency authorized by the government to do so under the IT Act. Precisely 2 years before the Menon made this statement, a report on unauthorized tapping of the phones of a senior political leader and the spying a Muslim dominated area and different cities by the NTRO created a furor in the Indian Parliament, while using research organizations for technological eavesdropping. The Indian government has also sought to monopolize all powers of surveillance by exercising governmental authority over it, turning any private surveillance by public sector units (PSU), private vendors, and the private detective agencies into electronic trade trespass punishable under the ITA. In keeping with its claim to exclusive authority in matter, the Indian government has sought to submit competing claims by the state governments and the armed forces to governmental scrutiny. And to June 2012, for example, the Home Ministry asked all the state government and PSUs to furnish a list of off-air interceptors in order to curb instances of the illegal phone tapping. A controversy erupted when the PSU Bharat Electronics Limited claimed to have sold interceptor to the Defense Intelligence Agency, but the army had not reported as having acquired in its disclosure to the government. Cyber security architecture as envisaged by the Menon has manifold ramification. The construction of the spectral terrorism, as discussed earlier, evidently permits the state to devise a specific surveillance and control mechanism for the focused, targeted, and systematic identification of the suspect activities. This assumes a semblance of routine normalcy, whereby citizens submit willingly to the protection of the state. Often, however, the surveillance is not through digital devices but at the ground and through the eyes and ears and living cameras of the state. The next section of this chapter will discuss how a combination of technological and human spying as well as surveillance has been employed in the specific context of the counter-terrorist operation in India, spatial policing and UAV mapping in the Chhattisgarh. In 2004, the Indian government identified Naxalism as another war of the terror, labeling it as the biggest internal security threat to the country. The insurgents of the left-wing extremists and the mineral and natural resources rich forest corridor straddling several states West Bengal, Jharkhand, Odisha, Chhattisgarh, Andhra Pradesh, Maharashtra is often described as the Naxal and the Maoist terror in official circles. And this corridor, the particularly in Chhattisgarh and the Naxals have waged a relentless armed struggle the protection of the rights for the protection for the protection of the rights of the Adivasis against state-backed corporate interest. In Chhattisgarh, the security apparatus of the state, reinforced by the legal regimes of exception, has created borderlands within the national security of India. Large tracts of the topography of the Chhattisgarh have remained unmapped because of its practically uh, impenetrable terrain. For example, in the Bastar region of the Chhattisgarh, administrative anxieties have often centered around the fact that the Ombudsman area have never been mapped or surveyed on the government apparatus and concerned about the fact that they do not know enough about these remote inaccessible areas. A primary concern of both of central and state governments has been to extend and deepen their control in these areas. This concern has resulted in a multi-pronged strategy designed in the facilitate and mount effective surveillance and control. Dedicated security forces with a variety of nomenclature and highly specialized modes and tasks of policing have proliferated in the state. The Dantewada, Dantewada area of Chhattisgarh, the police are referred to as the force. This is a blanket expression for the diverse combination of the organizational structure that constitute it. The local police, central paramilitary forces such as Central Reserve Police Forces, CRPF, Border Security Forces, and Indo-Tibetan Border ITBP, and the SPU, Koya Commandos. Interestingly, the names of many of these forces reflect the special functions they are expected to perform, that is, the task of smelling, flushing, and hounding out the Nakshals from the jungle habitats and hideouts. The examples of such forces are the Giri Hound in the Andhra Pradesh and the Central Government Commando Battalion of Resolute Action Center Cobra. Central Commando Battalion for Resolute Action Cobra. The powers of the security forces are enhanced by the special security laws such as CSPSA, which, along with the UPAP and the section of IPC pertaining to sedition and waging wars against the state, have been used widely by the state government. Indeed, the deployment of the law in the state has been primarily to buttress policing, so that law may be seen as having become what David Scott calls a direct means to achieve the primary political end of commanding evidence. Given, however, the Naxals have support among the Adivasis, which makes it difficult for the government to distinguish one from the other. The state has resurrected the colonial practice of the community policy. It has invoked provisions of the IPA to set up a force of SPOs drawn from the Adivasis community. The SPOs have become crucial in the state's war on terror, not just in Chhattisgarh but also in the West Bengal, Odisha, and other parts of the country, including Manipur, Jammu and Kashmir, where the condition and armed conflict persists. While part of the wider power structure of the state, the SPOs are also insiders of the community. They are and therefore indicative of the broader framework of the governmentalization of the state. As insider, they know the language of terrain, are familiar with the state's adversaries and their strategies against the state, and most importantly, as indistinguishable from them. The IPA, which provides the legal basis for the recruitment of the SPOs in Chhattisgarh, was reflective of the logic of the colonial state to maintain rule by force and the elect habitual evidence from the subject population. In its current uses, however, the deployment of the SPOs has become an integral part of the strategy of the state government for combating armed groups. It also now coupled with the efficacy argument of recruitment and deployment of the locals in order to avoid the logical concern relating to troop movement over long distances and the possibility of effective utilization of the local intelligence. While the SPOs are the state's eye and arms working from with in the enemy territory at the ground level, the electronic eye mounts surveillance from the sky, conveying information generated from around a dozen UAVs over the Naxal control Bastar area of Chhattisgarh to security forces on the ground. The NTRO receives and processes data in the form of the satellite images and audio generated by UAVs Naxal controlled areas and relies them in the real time to field level commanders of the CRPF stationed in the state. The officers claim to be receiving clear picture of the training centers, movement of the insurgents and the local of their camps from the UABs as well as GPS positions in the state. However, it is not immediately clear whether the electronic eye has resulted in a successful operation on the ground and is capable of replacing human intelligence. biometrics and the regimentation of the democracy. Over the past few years, both counting the population and its biometric marking have become central to the welfare, security, and surveillance regime of the state. There has been an intense debate in the particular on the UID, or as it was subsequently named, Aadhaar scheme of the central government, which aims to bring in a single standard form of the identification of all residents in the form of 12-digit identity number. This number is unique because it is not just a figure, it also includes biometric information lifted from the body in the form of the digital image of the iris and the fingers and the thumbprint. The UID scheme in India is supposed to have be registered biometric and demographic information of all residents and not just citizens in India, along with the National Population Register (NPR), now, which is parallel identification scheme of central government for the registration of all citizen non-resident. The UID becomes an inextricable component of the surveillance regime in India. Significantly, the preparation of the NPR was provided for by the Citizen Act 1955, Citizen Act, as amended in 2003, and the citizenship registration of citizens and the issue of national identity card rules of 2003. The 2003 amendment of the Citizenship Act made the registration of the all citizens of India in the issue of national identity cards and the maintenance of the national population register and the establishment of the national registration authority by the central government compulsory, unlike the Census Act 1948, which contains confidentially provisions. The Citizenship Act guarantees no privacy or the protection of the data on the individual citizens in the NPR. The Planning Commissions of India commenced the UID project in 2006 with the purpose of providing an effective method of identification of all residents across the country so as to ensure the efficient delivery of the welfare service facilitated facilitated by the Department of the Information Technology in the Ministry of Communications and Information Technology. The scheme is being vigorously promoted by the central government. In 2009, the UID Authority of India was created, and NPR and the UID schemes were brought together under its aegis for the collection of information, while UIDA insists that acquiring UID or Aadhaar card is voluntary. This card has the potential to become the most ubiquitous identity card in India. This it because most services are likely to be linked to the UID eventually, making it something that all citizens must possess. Since the UID is expected to facilitate delivery of service, it has to work in concern with the organizational service providers such as the Rural National Rural Employment Guarantee Scheme, the Income Tax Department, the Passport Authority, banks, and the insurance company. The need to uh, says data may potentially lead to the concentration and coverage of information in a single authority, the UIDI. Moreover, the UID enables the central government to put a security trace or on any individual. The setting up of a national intelligence grid for sharing the database of the various government departments and intelligence agencies gives material basis to the possibilities such as interlocking system would enable to state to identify profile any individual and to track the activities of person who are already marked out as political dissenters and the security threat. The techniques devised to address concern around spectral terror have proliferated exponentially. The accumulation of surveillance regimes across anti-terror laws, those addressing the Nexus challenges in Chhattisgarh and mapping population, undoubtedly raise concern around how regimes of democratic rights and the constitutional freedom would be transformed in the process, while concern around the right to privacy and the freedoms of the speech and the association has been expressed both in the context of electronic surveillance and biometric marking of the individuals. Surveillance has been transferred into and the transfer of everybody everyday lives of the people, even evidently the question of the constitutional right and securing democracy at the contemporary moment in the precarious tightrope.